Hi, it's Shan Wu with an Undercolor of Law hot take. Today I'm going to deconstruct the views of some of the legal pundits who have emerged criticizing the Manhattan DA's case against Donald Trump, now underway in my hometown, New York City. Name of the case, The People versus Donald Trump. And it's based, as we all know, on Trump's falsification of business records to conceal money he paid to people to stay silent about stories that could have hurt his 2016 election chances. I suppose we should expect that as the case gets underway with jury selection, Trump's statements grow more exaggerated. For example, take a listen to what he says here before he enters the court.
Reporters, it sure looks like he's going to.
Thank you very much. This is a trial that should have never been brought. It's a trial that is being looked upon, looked at all over the world. They're looking at it and analyzing it. Every legal pundit, every legal scholar said this trial is a disgrace. We have a Trump-hating judge. We have a judge who shouldn't be on this case. He's totally conflicted. But this is a trial that should never happen. It should have been thrown out a long time ago. If you look at Jonathan Turley, Andy McCarthy, all great legal scholars, there's not one that we've been able to find that said this should be a trial. I was paying a lawyer and marked it down as a legal expense. Some accountant, I didn't know, marked it down as a legal expense. That's exactly what it was. And you get indicted over that? I should be right now in Pennsylvania, in Florida, in many other states, North Carolina, Georgia, campaigning. This is all coming from the Biden White House because the guy can't put two sentences together. He can't campaign. They're using this in order to try and win an election, and it's not working that way. It's working the opposite way. So check it out, legal expense. It's called legal expense. That's what you're supposed to call it. Mr. Trump, you get indicted on that. Nobody's ever seen it. Nobody has ever seen anything like it. So thank you very much for coming. I'm now going to sit down for many hours. I am now going to sit down. The voters understand it. All you have to do is look at the polls. This is a sham trial, and the judge should recuse himself. This is totally conflicted. Thank you very much.
Every legal pundit, really, every legal pundit, every legal scholar says the trial is a disgrace? Hardly. But I did notice three pretty well-known ones who get a lot of publicity about their views, putting down the theory of the case. So let's examine their points of view together. And I think what you're going to find is that their legal analysis is not that sound, and in many cases, it isn't even really legal analysis. They all tend to refuse to recognize this case for what it is, which is that it's an election interference case. There are different reasons they have trouble recognizing it for that, but let's review the basic facts. There's a plan by Trump and the National Enquirer to, quote, catch and kill stories that could have hurt his campaign back in 2016. Stormy Daniels, the actress and director, the model Karen McDougal, were two such stories that Trump's team deemed potentially fatal to his election because it was coming on the heels of this Access Hollywood tape, where, as we may recall, he was caught bragging on tape about being able to grab women by the genitals without their consent, groping them, kissing them. Now, today, it may be a little bit hard to remember just how shocking that story was back in 2016. That's because I think we've all become so accustomed or numbed to Trump's actions that he's normalized so much of what used to be deemed completely unacceptable or fatal to a politician's chances. But to give us an idea of just how bad the tape really is, the judge in this case, Juan Merchan, has ruled so far that it can't even be played to the jury. The transcript can be shown, but not the actual video. Presumably, the judge is feeling that actually seeing and hearing Trump in real time on the video saying these things would be so prejudicial about his character that it would outweigh any benefit in terms of evidence. Now, I don't agree with that decision, but it does convey just how bad an effect that video can have on people. And certainly, back in 2016, in the final weeks of the election, it would have and did send Trump's team into a panic crisis control mode. Now, that likely motivated their urgency behind paying Stormy Daniels and others to stay silent. Now remember, the crime isn't the payment of money. I mean, you're allowed to pay somebody to be quiet about something, for example, through a non-disclosure agreement. No, the crime is the fact that Trump falsified business records to conceal those payments, to disguise the real purpose of them. They were money spent, obviously, to further his campaign chances, but they weren't reported that way. So it's pretty straightforward. You can make a contract with whoever you want and pay them for confidentiality and silence. But you can't then try to hide the payments by falsifying business records. That's a crime. And if the money is being spent to help your campaign, then you need to disclose that under campaign finance laws, because the whole point is for there to be transparency in what's really being spent on politicians' campaigns. So let's take a look at whether three well-known commentators get this right. First up, we have Professor Jonathan Turley of George Washington University Law School. You may remember him from the impeachment proceedings. Here's what Professor Turley had to say on Fox News. And let's take a listen, and I'll talk to you on the other side.
In this case, you're taking this misdemeanor, reviving it because it was dead, suggesting a crime that doesn't exist, and then hitting Trump with dozens of counts. Most citizens, at least outside New York, see that for what it is. It's the weaponization of the criminal justice system.
A crime that doesn't exist? What is he talking about? So first, as far as I can tell, Professor Turley has never worked in the prosecutor's office, although he did serve as an intern for the Department of Homeland Security before embarking upon a very distinguished career as a law professor. But as a law professor, he should know that the crime of, quote, first-degree falsifying business records under New York law certainly exists. You might also think he would know that it has been charged quite frequently by the Manhattan DA's office. How frequently? Well, in fact, from 2014 to 2023, it's been charged some 10,000 times. So that's a lot of existence, if you ask me. And that's something you can look up yourself as to just how many times it's actually been charged. Then there's Professor Robert Hassan, a UCLA law professor, and he's an expert on election law as well as campaign finance. He writes in the Los Angeles Times that it's hard to muster even a meh over Trump's New York criminal trial. His words, their headline. In support of this, the election law scholar says, and I quote, "Although the New York case gets packaged as election interference, failing to report a campaign finance payment is small potatoes in terms of campaign finance crimes. Willfully not reporting expenses to cover up an affair isn't interfering with an election along the same lines of trying to get a Secretary of State to falsify vote totals or trying to get a state legislature to falsely declare there was fraud in the state and submit an alternative state slates of the electors." So he thinks that you can draw a distinction between the kinds of crimes here. He writes, "There's a fairly bright line between attempting to change vote totals to flip a presidential election and failing to disclose embarrassing information on the government form. If every campaign finance disclosure violation is election interference, our system is rife with it." End of his quote. So let's think about what this election law scholar is implying. He's saying, don't bother to prosecute election law violations because it's done all the time. That's the kind of moral relativism that buys you corruption and dictatorships. But even the professor's own internal logic doesn't make any sense when you read through his full opinion. Because after putting down Trump's actions as, quote, small potatoes, he then references the charging of former Senator John Edwards as an example of a failed campaign finance violation prosecution. Presumably, he thinks it failed because it's not really important to prosecute campaign finance violations. John Edwards was not a small potatoes case. Edwards was a former presidential candidate and the former Democratic vice presidential nominee. I've been at a high level in the Justice Department. I served as the counsel to the Attorney General. I can tell you there would have been a lot of careful consideration before bringing a case like that. Now, by the way, do you know who was the prosecutor who tried the John Edwards case? Jack Smith. Yep, the same Jack Smith who has brought charges against Trump as a special counsel for election interference and mishandling of classified documents. Now, Professor Hassan's closing argument is the following. He says, quote, anything less than a felony conviction would only embolden Trump. He has already convinced a chunk of Republican voters that all the claims against him are a, quote, witch hunt. A hung jury or acquittal or even a conviction on minor charges would only feed the lie that all the indictments he's racked up are bogus. End of his quote. I'm sorry, but the fear of losing is not the way to dispense justice. Prosecutors should charge the crimes that the evidence proves. Now, last up, the Washington Post columnist Ruth Marcus, who did go to law school, although she doesn't practice law, she entitles her piece, quote, why did this seamy Trump trial have to be the first, unquote. In a lot of ways, that headline says it all, Marcus's pearl-clutching perspective on the case. Now, what strikes me about her opinion piece, it's not really the faulty legal analysis, because she doesn't really do any legal analysis. She speculates about how a jury might hang. She writes, quote, so the case will go forward starting Monday, but it's not hard to imagine that jurors could balk. It just takes one to produce a hung jury at shoehorning Trump's payments to Daniels, however odious, into the tangential crime of falsifying business records, which was outlawed to ensure that New York citizens, businesses, and investors could rely on the financial accuracy of corporations operating in the state. How were voters harmed by false bookkeeping entries they never saw? Now, holding aside the fact that that's so wordy, she should be teaching law, actually, here's the answer to the question. Voters were harmed because there was a violation of campaign finance laws, which are meant to keep campaigns transparent. That's how they were harmed. This is hardly insightful legal analysis. Any jury can hang. Everybody knows that. She also goes on to try to give her expert views on Michael Cohen as a witness. That's Trump's former lawyer. And she writes, moreover, a key witness in the case, Cohen, is a serial, admitted, and convicted liar. Perhaps one reason federal prosecutors did not pursue the election case against Trump in early 2021. Cohen pleaded guilty to lying to Congress, and she writes, when he tried to get his sentence reduced, prosecutors resisted, arguing he had lied to them in his interviews after promising to cooperate. Most recently, a federal judge denying Cohen's bid to be released from court supervision said Cohen had admitted lying under oath when he pled guilty to tax evasion, unquote. Okay, so what is she really telling us there? We all understand Cohen pled guilty. We all understand that he's going to be cross-examined over that. But she adds, quote, in short, Cohen is a defense lawyer's dream, unquote. As a former prosecutor, I beg to differ. I've also been a defense lawyer. Cohen is not a defense lawyer's dream. Even though he's talked a lot publicly about his views on Donald Trump, he has never wavered from the basic facts that formed the evidence of the payment to Stormy Daniels that was covered up. No, what's striking to me about Marcus's point of view is the sense you get from her that important cases can't involve anything she deems to be, quote, seamy. And while it might be a pet peeve of mine, I don't like her throwing around the term porn star that way. For a couple of reasons. It reminds me of when I prosecuted sex crimes cases, how there was a built-in prejudice against investigating or prosecuting sex crimes involving victims who were involved in any kind of sex work or ones who might have been trafficked. Think about it this way. Imagine that Marcus says this B-list actor, as though the fact that an actor is a, quote, B-list actor means that they're going to make a lousy witness. Of course, using the term porn star is a lot more pejorative, but you get the idea. What should count is really whether or not the strength of the evidence, the credibility of the person testifying is going to be strong. That's what you need to judge them on, not the kind of work that they do. You might get an idea of where Marcus stands on these kinds of issues when you take a listen to what she talked about with regard to the district attorney in Fulton County, Fani Willis. You might recall that Willis was the victim, in my opinion, of quite a smear campaign in trying to get her disqualified. Let's take a listen to what Ruth what Ruth Marcus had to say about that Fonnie Willis disqualification effort. I'll talk to you on the other side.
Behavior by a prosecutor. I'm sure lots of people watched Fonnie Willis and thought, you go girl. I watched it and I cringed. This is not the kind of information and behavior and observations that we want to hear from our prosecutors. I thought she, in one sense, stood up to Donald Trump and his allies, but she really, while she'll survive this episode in terms of disqualification, I thought she really tarnished herself.
So Ruth Marcus cringed not at the racist, sexist smear campaign against Fonnie Willis, but about Willis defending herself. You kind of get the sense that maybe for her, the only proper cases, prosecutions, or cases at all, are ones she thinks are prim and proper. The real problem with all three of these points of view is that it reflects one of the big sources of injustice within our criminal justice system. And that's the misuse of prosecutorial discretion and the misuse of really law enforcement discretion. Prosecutors get to choose which cases they bring. And too often, opinions like those being expressed by Turley, Hassan, and Marcus have factored into those decisions. Sometimes it's conscious, sometimes it's unconscious. But the result is it shields the powerful from accountability. Oh, it may come masked as this is too novel a legal theory to try, which really means we're afraid of the embarrassment of losing a high-profile case. And it also can mask a fear of losing because the person they're going against is a celebrity-type personality. Interestingly, the DOJ manual expressly flags that as an improper reason to decline a case. Prosecutors can't be afraid to take on a popular personality or to take on an unpopular cause. It's the justice that counts. It's not a popularity contest. Whenever these kinds of excuses materialize, what it almost always means is that the privileged and powerful are being protected at the expense of the rest of us. So I'm Shan Wu. This has been a hot take on Under Color of Law as the Trump trial is getting underway. I look forward to hearing your comments and suggestions. Keep those comments coming. I really appreciate the input. We'll see you soon.
Enough! Send it to the big house, not the White House. Get the new exclusive tees, mugs, and stickers right now at store.MeidasTouch.com. That's store.MeidasTouch.com.